welcome to today's Crossing Borders broadcast. Before we start, I just want to thank those of you who joined us yesterday for the session on global real estate and investment migration. A recording of that broadcast is available on our YouTube channel library, so please visit YouTube and search for Investment Migration Council, and there you'll be able to see the whole catalogue of sessions and broadcasts that we've run in the past 4 weeks. Remember, for today, you can ask questions in the Go to Webinar widget on the right of your screen. There are nearly 300 viewers with us today, so we'll try and get through as many of your questions as possible. So to keep you engaged, we've also got a few polls to get us going and test the system out. So you should be seeing a poll on your screen. Just launching that right now. So if you can take a moment to answer that, it'll give us an indication of whereabouts in the world you are. All right, we'll give you a few more minutes, or a few more seconds. Answers are still coming in. I see quite a few from the Americas. That's followed by Europe, Asia Pacific. Still collecting responses. All right, I'm going to close that now, and let's publish the replies. So there. So interestingly, Americas are leading the way, followed by Europe and 11% in the Asia Pacific region, followed by the Middle East with 8% and the African continent with 1%. So that's really good. I'm going to launch a second poll. It's a little bit of information that we want to collect from you about us. So answers coming in now. Still a few answers coming in. All right. Okay, that's slowed down, so I'm going to close that and publish the responses. So 57% didn't know and 43% didn't know. All right, that's quite interesting. So obviously very good for us to know. In the widgets, the Go to Webinar widget on the right of your screen, you can find a handout about the IMC course. And there's also a short video at the end of today's broadcast that we will broadcast, so do stay along with us. I'm going to close that now, and today I'm joined by distinguished US immigration attorney Ron Klasko. Ron is the managing partner and investor team chair of Klasko Immigration Law Partners in Philadelphia. He's also a former national president of the American Immigration Lawyers Association. His career in law spans over 30 years, and we're also very honored at the Investment Migration Council because Ron sits on our governing board. So welcome to Crossing Borders, Ron.
Good morning from the US and good afternoon to you.
So in today's session, we'll be discussing US visa and permanent residence options for investors and how they are impacted by the coronavirus pandemic, including, of course, the closures of consulates, the travel restrictions and the travel bans. And then against this backdrop, we'll also compare and contrast E2 and L1 visa options. And then we'll move on to EB1C and, of course, the EB5 green card options. And we'll look at other possible strategies. And the program will, of course, focus on how the pandemic is impacting EB5 investments, the timing and filing of E2 visa applications, and the issues relating to problems with leaving the US and or trying to return to the US. But Ron, first of all, many of our viewers will be very intrigued by President Trump stating he will sign an executive order to ban all immigration into the USA. What's the latest on that, please?
Yeah, so kudos to you, Bruno, for having the foresight to schedule this within 12 hours of President Trump actually issuing the executive order that very significantly restricts immigration to the U.S. So we will be the first program to talk in some detail about what this executive order does. And it's effective at midnight tonight, U.S. time. And that will be the first topic of our conversation.
Perfect. Ron, how long is that executive order going to be in place for?
So it's set to be in place for 60 days starting tonight. In reality, we expect that it will be extended, most likely beyond 60 days, but at least for now, it's limited to 60 days. So maybe, Bruno, before we get to the slides that I do want to talk about in some detail, probably this is our best starting point to talk about what this executive order does. So the executive order is premised on the problem of unemployment in the U.S. It's not focused so much on the pandemic as such, but it's saying because we have gone from record low to record high unemployment in the U.S., we need to do things to close our borders rather than having immigrants come to the U.S. and compete with the U.S. labor market. Different people have different views as to whether that is the real reason, whether it is really going to be limited to 60 days. I think most people think probably we're going to see extensions of this executive order, both in terms of its length and probably also in terms of what it covers. So what does it cover?
Yeah.
So it covers people who are immigrating, and that's a key term of art in the U.S., immigrating to the U.S. There's a difference between immigrating, which means coming permanently with a green card, and coming on what's called a non-immigrant visa, such as the E2 and the L1, where you're not coming permanently. This does not affect E2 visas and L1 visas and other non-immigrant visas. It only covers immigrant visas. Now, interestingly, there's very few exceptions to the coverage of this for people getting green cards. There's exceptions for people involved, as you might imagine, in healthcare and medical research involving COVID, in basically being involved in somehow combating the effects of the pandemic. Those people are accepted. Spouses and under 21-year-old children of U.S. citizens are accepted, but very few other exceptions. However, the one category that is entirely outside of the executive order is EB5. Now, for many people, that came as a total surprise, a happy surprise, obviously, for our audience of high net worth investors. And probably the reason for that is that if the entire executive order is premised on unemployment, and if EB5 is a visa category that in order to qualify, you need to show you're creating 10 jobs per investor, it would be somewhat counterintuitive to say in the name of helping U.S. unemployment, we're eliminating a visa category that creates employment. So for whatever reason, we're happy to see that EB5 is not in any way restricted or banned by the executive order, but almost all of the other family categories and employment categories will not be able to enter the US for the next 60 days. Now, some people would say that as a practical matter, because of consular closures, which we're going to discuss, nobody was coming here anyway for those 60 days. So some say it is merely a political statement showing that we're doing something. I do expect that the biggest impact of this will be not this executive order, but future extensions of this executive order for longer terms, and possibly extensions of the executive order to cover things other than green card holders that could possibly in the future include e-visas and L-visas, which means that based on that, we are looking at doing everything we can to move forward even more quickly with non-immigrant visas such as E's and L's before this executive order gets extended. So that's pretty much it on the executive order. I want to talk about what has happened since COVID, since the pandemic, but maybe just as a backdrop, it's worthwhile spending a few minutes talking about where we were before anyone ever heard of the word COVID. And of course, yes.
That's really interesting, Ron, because what we've seen over the course of the past few weeks is the Trump administration making essentially sweeping changes to the US immigration system. I think I was reading one article yesterday that in the course of just a little over a month, there's been at least a dozen changes to the US immigration system, ranging from postponing immigration hearings to pausing deportation flights to certain countries, or removing migrants arrested at the border and suspending refugee admissions. So there's a massive, rapid amount of change that the administration has undertaken in the short few weeks on the premise of, because of the pandemic. So I think, you're quite right in that today's broadcast is really, really interesting because of all these changes that have taken place. So we want to hear about that.
Yeah. So really, I mean, you're certainly everything you just said, Bruno, is exactly correct. But one could argue that we have seen unprecedented changes in immigration laws for the last 2 or 2.5 years, and that's been exacerbated by the pandemic. So we, in addition to, well, we know about the travel bans. We know that the first travel ban that affected many countries, the most prominent of which was Iran, resulted in people being unable to come to the US as immigrants or non-immigrants. And actually that one of the interesting ways that the CBI was enhanced by that was because if you were a citizen of a travel ban country, but you got second or third country citizenship in another country, you could be able to enter the US using your other passport in order to avoid the travel ban. We more recently had travel ban 2. The most prominent country in travel ban 2 was Nigeria. But travel ban 2 only covered immigrants, not non-immigrants. So for example, using Nigeria as an example, the travel ban restricts the ability of someone from Nigeria to be able to immigrate to the US with a green card, but does not affect the ability to immigrate to the US with a visa. So for example, if a Nigerian citizen becomes a citizen of, let's say, Turkey or Grenada, they would still be able to get an E2 visa. However, becoming a citizen of Turkey or Grenada or any other country would not get you out of the green card travel ban. So we've had travel bans, we've had unprecedented restrictive interpretations of various visa and green card categories. That was all the pre-pandemic picture in the US. Then along comes the pandemic, the last month or two, And we're going to be spending a lot of time now talking about where we are. Perhaps this would be a good time, Bruno, to do the poll question we had.
Let's bring that up, Ron. There we go. So that should be on everybody's screen now. So what we're asking today is, how has the COVID-19 pandemic affected your plans to immigrate into the United States of America? And you've got 4 options. No impact. I feel it is more important than ever. I am less interested or not interested. I'm still interested, but my strategy will change. The replies are just coming in. And those results are still coming through. I'm going to give you a few more seconds. And then, Ron, you're probably quite keen to start your presentation as well, I think. We've already got quite a few questions that are coming in. So probably hang on to those till the end, right?
Yes, please. Because it may be that I'm going to be answering a lot of the questions as we go, but I'll be available to answer questions at the end for sure.
And I'll moderate those and see which ones you've answered. We won't put those to you. So okay. Let's show the results of that, and here are the results. So overwhelmingly, the COVID-19 pandemic hasn't affected your plans or your clients' plans to immigrate into the US. And here, of course, we only gave the possibility to choose one option.
Interesting. All right, well, Bruno, let's go to the slide called the big picture and get started talking about what has happened as a result of COVID-19 relating to U.S. immigration.
Absolutely. So let me switch and make you the presenter, Ron. And now we can see you. If you could open up your PowerPoint and put it on screen. So we'll just get that up. Incidentally, for the audience, while Ron's pulling up his PowerPoint, if you've got questions, then use the widget on the right-hand side in the GoToWebinar panel, and we'll get through to your questions at the end of Ron's presentation.
Are you able to control the PowerPoint, Bruno?
I can do, yeah, absolutely, Ron.
Why don't you do it?
Let me switch that over. I'll show my screen so everybody can see my screen, and I'll start moving the PowerPoint.
So while you're doing that, Bruno, I want to talk now about what has happened since COVID-19. And as the PowerPoint says, up until the executive order of last night, the law has been the same. Nothing's changed. But in reality, a lot has changed. So first of all of the U.S. consulates around the world are closed and have been closed and will remain closed indefinitely, except for what each consul may consider to be emergencies or essential services. But for all practical purposes, the consuls are closed. We do not know when they're going to reopen. We do not know if and we expect some may open sooner than others. And we expect that they may open in phases. They may be open for some things and not other things. So as the attorney for lots of people who are interested in making applications at consulates, we really deal consul by consul to find out, are they accepting applications even though they're not interviewing? Are they not even accepting applications? Can we get in line? And we're dealing consul by consul on that. At the same time and the consul, of course, is necessary because if you want to get a visa or an immigrant or a non-immigrant visa to come to the US, you have to do it at US consulate. By the way, the executive order, I should have mentioned this, does not cover people in the US. So if you're in the US applying for a green card, the executive order does not cover you. If you're in the US applying for a visa for an extension of your status, it does not cover you. In addition to consuls being closed, borders are closed. The border with Canada is closed. The border with Mexico is closed. For now, it's closed until the middle of May. Again, we don't know if that will be extended or not. Essential travel, and that's very ad hoc determinations, are exceptions to that, but the borders are closed for non-essential travel. In addition to border closures, and in addition to the travel bans I talked about, which were pre-pandemic, we also have travel bans created by the pandemic. So the first one was for China. And the first thing that President Trump did to address the pandemic situation is prevent the entry of people who had lived in or traveled to China in the last 2 weeks were prohibited from entering the US. And each of these have some exceptions for close family. And that travel ban continues to exist. That was followed later by a very similar travel ban for people from Europe, which was later extended to include England and Ireland. And that's also a ban on entry for anyone who has been in any of the 26 European countries within the last 14 days. And that also is extended through about the middle or so of May, subject to further extensions after that. So we have consulate closures, we have border closures, we have travel restrictions, we have travel bans, all of this unprecedented in the US. And added to that is our country has gone from unprecedented low unemployment to unprecedented high unemployment within a matter of a couple of months. Now, immigration policy everywhere in the world is generally impacted by employment and unemployment levels. And as I mentioned before, the high unemployment is the premise for the executive order largely banning immigrants from coming to the US for a period of time. For high net worth individuals generally, there is no employment test as part of getting a visa or a green card, other than EB-5, which has the test of creating 10 jobs for every US worker. And the reason that EB-5 is likely exempted from the travel ban is it's a job creation program rather than a program that could be said takes a job away from an American worker. One of the reasons I expect that there will be further extensions of the travel ban or of the executive order is because many of the people in the US advocating for restrictions are really more concerned with non-immigrant visas and their impact on US employment more so than immigrants. So I do think we will need another webinar in the future to talk about other changes. The next thing I'll mention is even though almost everything all deadlines have been extended because of COVID. In the US, your tax filing deadlines of April 15 have been extended. Virtually every government agency has, for obvious reasons, extended deadlines. For the most part, the Immigration Service is the exception. They have not extended deadlines. Lots of people are in situations where they are all of a sudden finding themselves deportable because they can't meet deadlines. We as US immigration lawyers are very busy dealing with each client's situation on that. And we actually have, the American Immigration Lawyers Association has actually filed a lawsuit in federal court to try to compel the Immigration Service to extend deadlines for many people who are now all of a sudden unemployed, can't get another job overnight, can't get the documents they need to apply for extensions. This is a big issue in the US. So let's go to the next slide and talk about EB-5. So EB-5 had a number of changes that preceded COVID and a number of changes being caused by COVID. So before COVID, we had, as of November 21 of 2019, we had vastly higher investment amounts for most projects. Before November 21, the investment amount was $500,000. Now for most projects, it's $1.8 million. And for some projects in targeted employment areas, it's $900,000. So obviously that had a significant impact on demand for EB-5. In addition, the processing times for EB-5s have gotten way longer. They have, in many cases, tripled, quadrupled, quintupled, and the USCIS now lists 4 years as normal processing times, although usually it doesn't take quite that long. But the bottom line is this is a much longer process than it was before, for many investors are filing what's called mandamus cases to get courts to force the quicker adjudication of their applications. So that was where we were before COVID. Since COVID, there's two big issues we're dealing with. One is project delays and the impact on job creation, and the other is what's called material changes in projects. So we want to talk about this in a little bit of detail. So obviously, or maybe it's not so obvious, but in almost all jurisdictions around the US, there are orders from the state governors and sometimes other city and municipal officials stopping construction projects. Well, since there's two types of EB-5s. There's direct EB-5, which is you're investing in your own business, and there's regional center EB-5s, which are the majority, where you're often investing in a construction project. So in either event, there's likely to be delays. If you're investing in a construction project, whatever the construction timeline was, it's now likely being extended, probably not by months, but maybe by years. And this has an impact because you have to show that jobs will be created, at least 10 jobs per investor. Now, there's various strategies we're using, and for most of our projects, we do not think there will be problems with the EB-5 applications. Number one, in many cases, the jobs through the construction necessary number of jobs may already have been created before the construction stopped, and that's sufficient if they were created. When we deal with direct EB-5s, if you've started your own business, maybe now business is down, you started a restaurant, and at its peak, your restaurant had 30 employees, so you created the necessary jobs. Now you're down to 5 employees because the restaurant is only doing takeout or delivery. There is a very good legal argument that what's necessary is showing you created the 10 positions. And even though those 10 positions aren't actually filled today, they still exist when things go back to normal. Also, there's no requirement in EB-5 that the jobs be created immediately. And in fact, the jobs do not have to be created until 30 months after the approval of the EB-5 petition. And if EB-5 petitions are taking 2 or 3 or 4 years to adjudicate, and you file a petition and you don't have to create the jobs for 30 days after 2 or 3 or 4 years, you have a lot of leeway on job creation. So this is a big issue, but in various ways, we hope to be dealing with it for all of our clients. The next issue is what's called material change. So USCIS takes the position that if there is something called a material change that occurs before you become a conditional permanent resident of the US, before you get a green card, that you basically have to start all over again. And there's a lot of challenges to that, but the question is, what's a material change? Now, we believe, and again, there is no definition. This is a policy that the Immigration Service has made up. It's not in the law, so there is no definition of it. We believe that, for example, a delay in construction, a change in the construction timeline, is not a material change. We believe that there's at least a reasonable argument that if, for example, you have a business plan for a restaurant, but now by orders of the governor and the mayor and everyone else, you can't have dine-in, and maybe we're not going to have dine-in for a while. That's certainly possible with social distancing. And so we're changing our business model to be more of a catering business or a takeout business. I would argue that that also is not a material change because, as I've said in one of my blogs, a business plan is not a statute. Business plans are meant to change. And when we have a program that is going to be going on for years after years after years, almost every business plan, every successful business plan changes as needed to be successful. The issue of quota delays is worth talking about. Now, so far, this has only affected people from China, India, and Vietnam. For China, it's a very, very long delay. And we're in the unusual situation where we have far greater demand for EB-5 numbers than there are numbers available, and that's what creates the quota delay. But because consuls are closed and other things, the numbers are not being used. And this is, up until last night, what was going to happen is the unused EB-5 numbers were going to go to other employment-based categories. But now, with all the other employment-based categories shut down by executive order, it will be interesting to see if the unused numbers in those categories will go to EB-5 and help the quota backlogs. So this is something that we're only 12 months into this executive order, and we're going to have to see how that plays out. So that's a lot of what's going on with changes in EB-5, both pre-COVID and post-COVID. The next thing I want to talk about on the next slide is E2 and citizenship by investment. This was certainly over the last year, year and a half, 2 years, starting to become a very hot topic for nationals of countries that do not have treaties with the US for investment, such as China, Vietnam, and India, such as South Africa, Brazil, and Saudi Arabia and UAE and many, many other, Russia and many countries around the world that do not have treaties with the US but have great demand for immigration to the US. So long before anyone ever heard of COVID, the process of getting citizenship by investment, usually in Grenada, to some extent in Turkey or Montenegro, all of which have CBI and E2 treaties, that was becoming a hot topic around the world. As far as I know, most or all of the CBI countries are continuing to process passport applications. I was in touch with the folks in Grenada just within the last week or so. I know that they are continuing to process passport applications, and actually to some extent doing it quicker than before. Certainly the infusion of money that comes from CBI at a time when many of these countries who rely on tourism are seeing no tourism. CBI, if anything, becomes more urgent, and we may see even more expeditious processing of passport applications. Many of the people who get CBI in Grenada or Turkey or Montenegro do so with the strategy of then availing themselves of the investment treaty with the US and applying for an E2 visa. Now, the E2 visa, as I mentioned before, is not subject to the president's executive order. So they can go forward and, because of the executive order, there may be even more interest on E2 if you can't get immigrant visas in other categories. But even though we can file these applications at some US consulates, but not others, we can't actually get our clients interviewed and therefore be approved until the US consuls reopen. So we do expect there will be a run on these, and probably, at least at many consuls, getting the application filed may be important to enable our clients. So since there'll be a backlog of interview appointments, getting our clients in line could be important to prevent delays in visa interviews, which we expect will happen once the consuls reopen. For the most part, in most US consuls around the world, we were getting our clients E2 visa interviews in anywhere from a couple of weeks to a couple of months. That may well get longer for obvious reasons now. I mentioned before that the second travel ban, not the executive order last night, but the travel ban that affected a number of countries, including Nigeria, only affected immigrants, not non-immigrants. So people from countries such as Nigeria are still able to process E2 applications if they get citizenship in a country that has a treaty. Another interesting thing is that, again, probably for obvious reasons, we have a situation where far more businesses are available for sale now than ever before, and at far lower prices than ever before. So if you're an E2 applicant, you need to start a business or invest in a business, invest at least to obtain 50% ownership or more of a business in the US. Well, if you were looking to buy 50% to 100% of a business, A, there's far more businesses available for you to look at, and B, you likely are going to be able to acquire them for amounts way less than you might have in February of 2020. But other than that, the basic requirements for the E2 visa remain the same. And I've done other webinars on what those requirements are. If you go to my website at klaskolaw.com, you'll see lots of information on what are the requirements for E2 visas. The next topic I want to talk about is usually the alternative to citizenship by investment and the E2 visa. So very often, our clients are looking at choosing the E2 option, which a lot of times will be followed up by an EB5 application, since the E2 investment amount can be used as, in effect, a down payment toward the EB5. The other route to go is the L1 EB1C. So let's take a look at what this is. So the concept of this is that we have a high net worth individual who is the manager, CEO, managing a division, whatever, the manager of a company outside of the US and has been for at least a year. And that company, whether it's the investor's company himself or a company that he's a part of, that company either has had or creates a new US subsidiary operation with at least 50% ownership in common between the overseas company and the US company. When we have that situation, the company can transfer the manager from the overseas operation to the US operation on an L1 visa. The L1 is a non-immigrant visa. It's not a green card. So again, it's not affected by the executive order of last evening. The L1 visa for some people is better than the E2, and for others, the E2 is better. Many of our high net worth individual clients are not particularly interested in being the day-to-day manager of a company in the US. Well, that is a requirement for the L1 visa. It is not a requirement for the E2 because the E2 can hire a day-to-day manager and oversee that person and meet what's called the develop and direct requirement of E2. But the L1 is meant for people who actually will be the manager of the US company. The E2 is investment-based. The L1 is not investment-based. The L1 is based more on, again, qualifying as a manager of a multinational company. Jobs are relevant for the E2. It's usually very helpful to show that your E2 business is creating at least some employment in the US, although that's very flexible. Employment is far more important for the L1 because under the Immigration Service definitions of a manager, managing levels of employees is a critical component of that. So those are some of the compares and contrasts between L1 and E2, and lots of our consultations with our clients overseas looking at options are comparing and contrasting the L1 and the E2. Now the L1 does lead to a green card in the EB1C category. And if you're in the EB1C is called multinational manager. If you're in the US with an L1, the executive order does not block you from applying for a green card in the US. Remember what I said at the beginning, it only blocks people from coming from outside of the US into the US with an immigrant visa. It does not block people in the US applying for a green card. So the EB1C says that once your US business has been doing active business for at least 1 year, you can convert that L1 into a green card through the multinational manager category by filing an application with USCIS. So all of that stays the same pre and post COVID, although the concept of a lot of these businesses that were hoping to have levels of employees are more likely now to be shedding employees, which may make some of these applications more difficult. Moving on to the next slide, I want to talk a little bit about the impact of travel restrictions to the US on various groups of people. And as we do this, and this will be if you're getting ready to ask questions, this will be the last slide before I deal with questions. So we have people who are US permanent residents who are now stranded overseas. There's a lot of issues here. So first of all, I should say that the new executive order does not prevent US permanent residents from returning to the US. It does not prevent that. And we also need to know that a permanent resident, as a general rule, is supposed to be living 6 months a year at least in the US, and in no event can be outside of the US for a continuous period of 1 year or more, unless they have something called a re-entry permit that allows them to be outside of the US for 2 years, but you can only apply for a re-entry permit if you're physically in the US. So COVID has resulted in many permanent residents finding themselves out of the US with big problems getting into the US. The problems may be a lack of flights. The problem may be just safety issues. They may be in a group of people that find it unsafe for their health to go on a flight. They may be now subject to the travel restrictions if they've been to Europe or China. And so they're unable to get back to the US within the necessary 1 year to avoid abandonment of their permanent resident status. And there are a lot of complicated things. A lot of our time these days is spent dealing with these issues for our clients. There is something called a special immigrant visa that we haven't used that much in the past that we now will use when US consulates open, which can be used by permanent residents who have stayed out more than a year if they can show there's a good reason for that, extraordinary circumstances for that. And obviously this is about as extraordinary it gets with COVID. The reverse of that is people in the US who are unable to leave the US. So their status is expiring. They don't want to be deportable from the US. They don't want to violate their status because that creates all sorts of problems in the future, but for the same reasons of lack of flights. There may, the country they want to go to is shut off to people entering that country. Again, safety issues. For a whole variety of reasons, people who want to leave the US can't, and we have to try to do things to protect them from being illegal in the US, and that's a whole different group of clients that we're consulting with on a regular basis. Many people involved, high net worth people involved with US immigration, are very concerned about their tax status, and they know that the issue of whether they're going to be taxed on worldwide income by the US is dependent on how much time they spend in the US, and they're very careful about that. Well, all of a sudden, they may not be able to leave the US, which could have major impacts on their tax status. And that's something we need to collaborate with accountants and tax lawyers and financial advisors for our clients. And also e-visa strategy has changed. So in the past, we have usually preferred to have our clients apply for e-visas at US consulates. If we have a client in the US on another visa category with consulates closed indefinitely, that strategy changes, and in many cases, we're going to apply for the e-status in the US at the Immigration Service. And the last thing before we go to questions are some issues relating to EB-5. And these are pretty serious questions for people who are already conditional permanent residents. So with EB-5, you get a 2-year green card, and you're able to travel. You get proof of your conditional permanent resident status, often issued 1 year at a time, and you're able to travel with that and come back. Well, now if you're stranded outside of the US and your stamp has run out, and you may not be able to get another stamp, and you're going to end up outside of the US for longer than you're allowed to, these are huge problems we're dealing with for our conditional permanent resident clients. And the last group on EB-5 is people who have been approved for an immigrant visa, but have not used it yet. As a general rule, you have 6 months to use your immigrant visa to enter the US. Now, long before the executive order, there were issues with that. People, you get your immigrant visa issued, your kids are in school, we're going to wait 4 months till the kids are out of school, and then we'll enter the US during the 6 months. But now those, now the schools are closed, but now we can't get to the US, and our immigrant visa is going to expire. And again, these are case-by-case situations. In some cases, we may be able to renew the immigrant visa at a US consulate once they reopen, but the executive order throws that strategy into question. So lots of things that we're very busy working with our clients on that are either direct or indirect impacts of the worldwide pandemic. So I hope that that addresses the concern of many of you on the call, but I imagine there's still some questions that I didn't answer, and I'll be happy to do that now.
All right, thanks very much, Ron. We've got some questions coming in, quite a lot, a little bit on Twitter as well, but mostly through the panel. I'll start off with one that came both through our Twitter channel and on the webinar. And that is, within how many months can the L1 manager apply for a green card?
So the L1 manager can apply for a green card immediately upon entering the US as an L1, as long as the business that they are managing has been doing active business for at least 1 year. So there's a difference. If you're starting a brand new business, then you can't apply for the EB1C until your brand new business has been doing active business for a year. That's at least a year down the road. If you're buying 50% or more of an existing business, and that business has been active for a while, you can either immediately after coming here as an L1 apply for the green card in the EB1C at the Immigration Service in the US, or for some people, they say, well, I'm going to skip L1. Since I have a business that's been active for more than 1 year, I can go directly to EB1C, especially if I'm not in a big rush to get to the US. With the L1, you can get to the US very quickly. With the EB1C, you're probably looking at 1.5 to 2 years to get here, maybe more.
All right, Ron, but if someone is specifically looking at the L1, how long would the process take to get a green card using the L1? Would you know that?
Yeah, so the L1 itself is pretty quick. You use what's called premium processing. You can get an answer in 15 days and you can come here. And let's say, if you have a business that's been active for at least a year, you can immediately apply for a green card in the EB1C category. Timing is usually going to be, I'd say, again, at least 1.5 to 2 years. So if your green card strategy is EB1C, you should plan on at least 1.5 to 2 years to accomplish that.
All right. Okay. Another one is, look, if jobs are eliminated because of the COVID-19, so you've got furloughs and you've got unemployment's about 20 million in the US now. Would those specific jobs be disqualified for the EB5 job creation program?
Yeah, it's a good question, and the answer is they should not be. And so here, people get confused on the issue of job creation. You don't have to show that these 10 jobs are there today. If your EB5 investment resulted in the creation of 10 jobs or 50 jobs, and now most of those people are gone, the law says that you have to show the jobs were created in the past, not that they exist today. So although this is very case by case, and we look at it, at the specific facts for each of our clients, in many cases, if the EB5 investor created the jobs, even though since the pandemic, a lot of them have been lost, we can still be successful with the EB5.
All right. I've got a question from somebody who's working on a H-1B visa and getting maxed out on the 3rd of May. They seem to be unable to travel due to the travel bans. So in order to keep a lawful presence in the US, what are the options?
Yeah, so again, another very good question, and this is something we're dealing with regularly. So the first thing we look at is when we say maxed out, in some cases, somebody who thinks they're maxed out may not be. Depending on how much they have traveled outside of the US in the past. Right. Because even if they've hit the maximum 6-year limit, we can add on every single day that they were outside of the US during the last 6 years. Now, let's say we do that and they're still maxed out. Well, then we have to look at other possible visa categories. One would be the E2 visa category. So if the person is already a citizen of the over 80 countries that have investment treaties with the US, we can look at the E2. If the person's spouse is a citizen of a treaty country. Sometimes the strategy is to have the spouse be the E2 investor. And the reason for that is the E2 investor can only work at the E2 company, but the spouse of the E2 can work anywhere he or she wants without sponsorship. So this would enable our client who's working for the H-1B employer to get a work document to continue to work at the H-1B employer even after the H-1B maxes out. So that's a strategy. Some of our clients qualify for what's called O1, extraordinary ability visas, and there is no max out on O1s. So that may be a strategy. So again, it's very case by case. On my website, klaskolaw.com, I have an article entitled 25 or more options for the capped out H-1B. It goes into what I just said and a lot more.
All right. So we've got a question here. Does the executive order apply to non-immigrants already in the US, probably in a H-1B or L visa, with employment-based green card petitions? So they're not entering the US as immigrants, but they're already here.
Yeah, so the short answer is no, it does not affect that person, but let me explain a little more detail. So number one is it definitely doesn't affect the non-immigrant H status because the executive order only applies to immigrants. So if the H-1B applicant is applying for a green card and is applying for a green card in the US through what's called the adjustment of status process, then the executive order does not apply to that. And the only caveat to that is, as I said at the very beginning of our program, I do expect that the executive order will likely be expanded in a number of different ways. If the executive order attempts to affect people in the US, and it does not now, but if it does in the future, it will almost certainly be subject to legal challenges because the basis for the executive order is a section of the law that only relates to the ability of the president to stop people from entering the US in times of national emergency.
All right. And Ron, we've got time for two more questions. What happens to a pending NIW petition after the executive order has kicked in?
Well, so an NIW, for those who don't know, is a national interest waiver petition. This actually raises some interesting issues under the executive order. So the short answer is nothing happens to change the pending NIW petition. All right. So the first step is I'm going to try to prove to the US government that what I'm doing in the US is in the national interest. If that's approved, then I can apply for a green card. And I can apply for a green card either outside of the US or inside of the US. The executive order says I can't apply for a green card outside of the US, but it does not prevent me from applying for adjustment of status when my NIW petition is approved in the US. Now, the only thing I'll add to that is that there is a provision in last night's executive order that exempts people who the State Department believes are doing something in the national interest of the US. Now, an NIW petition is not dealt with by the State Department. So one of many questions that we immigration lawyers are going to be dealing with is whether an approved NIW, national interest waiver petition, makes you exempt from the executive order, or whether a totally separate government agency has to make a totally separate determination of whether you're going to be doing something in the national interest of the US. The executive order is 12 months old. There's lots of questions. That's one of them. 12 months. The executive order is 12 hours old, and lots of these questions will have to be resolved.
All right. Thanks so much, Ron. There's one more question, you said quite rightly that the EB-5 is excluded from the executive order, but if Consulates are closed and travel is banned, particularly to places like China, which are a major source of EB5 investors. How is EB5 supposed to work if this, if the system is closed, so to say?
Well, Bruno, that's an interesting one to end on, and it's some people say, well, what does the executive order really mean? Nobody, without an executive order, nobody could get an immigrant visa to the U.S. because the consuls are closed, and that's the only place you can get an executive order. That's the only place you can get an immigrant visa, and the consuls may well be closed for another 2 months, so it doesn't matter. And by itself, that may be true, but again, I do expect it'll be extended. So for EB5, let's say the executive order is extended, as many expect. And let's say the U.S. consuls reopen in June. Well, it means then that starting June, people with EB5s will be able to apply for immigrant visas, even though people in the other categories will not.
All right. Ron, this has been great. Thank you for joining us. We didn't get time to go through all the questions. There are another 10. But what I suggest you do, members of the audience, is write to Ron. His address is on the screen right now, and put your questions directly to him. I'm sure him or his team will be able to get to the answers to your questions. You can also stay connected with Ron through Klasko Immigration Law Firm social media. They've got Twitter, Facebook, and LinkedIn through there. So thank you very much for joining us, Ron. That's all we have time for. We've run over a little bit. I hope you, the audience, have enjoyed at home and found it interesting. If you're not already a member of the IMC, then please open the IMC handout in the panel on the right of your screen for information on how to join us. If you're a member already, please visit the website and you'll see lots of updates, what's going on in the world of investment migration at the moment. We'll be back next Wednesday, always at 2:30 Central European time, and I'll be talking to 4 professionals based in Asia and asking them, is it really back to work in Asia, and what are the investment migration strategies looking like by Asian investors. So until then, stay safe, and thank you very much for joining us today. I'll close with the short video of the IMC. Thanks so much. And again, thank you very much, Ron.
Certification in Investment Migration from the Investment Migration Council, the first structured learning product of its kind globally, designed for you. Explore the bite-sized learning pathway of each module on our custom online platform. You can track your progress as you go and learn at a pace that suits you, with an estimated 5 hours of study time per module. The certification in investment migration contributes to the development of professional competencies and standards for those new to or already working in the industry. So, what are you waiting for? Visit our website to start your learning journey today.